Carole Taylor. On this edition of Journal, another look at the growing tension between Aboriginal title and individual property rights. This issue was brought to the fore by the NDP government's introduction of the Land Act last year, just before the election. It was a bit of a bombshell, as it indicated First Nations would co-manage all of the BC Crown lands. That's 94% of the province. Because this was done without proper consultation with all the many affected players, including private property holders and businesses, the resulting uproar forced the government to withdraw the act. Then this spring, an agreement between the provincial government and the Haida Nation announced the granting of Aboriginal title throughout Haida Gwaii. Once again, the question of private property rights arose. Does Aboriginal title override both government and private ownership? And now we have the momentous Cowichan court decision, granting title of land in Richmond to the Cowichan tribes. The voices expressing concern over private property are growing louder. In her judgment, the judge said, in part, that her decision may give rise to some uncertainty for the fee simple title holders. That means private property owners. She goes on to say it may have consequences for their interest in land. To help us sort out the actual legal issues and repercussions is one of Canada's top legal minds in the field of Aboriginal law. Thomas Isaac joins us to analyze these latest developments and what it means to homeowners. Back in a moment. Thomas Isaac joins us now, and thank you for coming back. But I remember our first conversation, we were talking at that point about title, and what title means and how it's different from rights. And I think people who are not in law sort of slide them together sometimes. And at that point you were saying title is far more comprehensive and serious than we were being told. Do you still feel that way?
Well, yes, I do, Carole. My comments are based on the guidance that we've received from the Supreme Court of Canada to date, notwithstanding other lower court decisions that we are getting, including the recent Cowichan decision. The Supreme Court of Canada has been very, very clear in its guidance on Aboriginal title, really since the Calder decision. And of course, we've got Delgamuukw, Marshall and Bernard on the East Coast, and Chilcotin, and they all point in a singular direction, and that is that Aboriginal title is a right to the land itself. It's not an interest in land. It is the land. And that is a key differentiating point between Aboriginal title and something like fee simple property rights.
And so what happens to private property? You're down the line?
Well, according to the Supreme Court of Canada, private property is a justifiable infringement. We know from Chilcotin that there's also fiduciary duty on the Crown. It can't erode Aboriginal title to such a point that it becomes meaningless. But what I would say is that that's not on a parcel by parcel basis, and that's what we see going on in Cowichan. If it was parcel by parcel, you'd never be able to justifiably infringe title. It would make Aboriginal title absolute, which is also contrary to about 70 plus decisions from the Supreme Court of Canada. So
the big picture, Cowichan comes down, and I think it was a shock to most people.
Yes.
And basically, the judge was almost saying directly that it's going to affect private property.
Oh, the decision affected private property rights immediately within the area that title was declared. But we can't forget that the judge, the court also, and for your viewers, I'll throw out a paragraph number, which by itself I think speaks volumes. Paragraph 3,551, the last sentence of that paragraph, where the judge writes, a precedent that will flow from this case is that sections 23 and 25 of the Land Title Act do not apply to Aboriginal title.
So that's
a verbatim quote.
So for us who are not lawyers, what does that mean?
Well, section 23, and you'll see companion provisions in all the provinces and territories in Canada and in the common law world. Section 23 lays out the rights that a private landowner has with their land. And these are akin to exclusive rights, subject only to the Crown. Section 25 is all the protections the Crown affords those rights. So, to put it a bit more bluntly, it is the heart and soul of fee simple property rights. The court said a precedent that will flow from this decision throughout all of BC, in this particular judge's view, is that those two provisions don't apply to land where Aboriginal title has been declared. So I've seen some things in the media about sort of fear-mongering and, well, it didn't quite go that far. Paragraph 3551 is an absolute express statement of what the court was saying. And so it's not just Richmond. It is very clearly directed towards all fee simple property in British Columbia.
Fee simple being
privately owned, whether it's owned by Indigenous people or non-Indigenous people.
That's an important point to make, that it wasn't just about a strip of land in Richmond. This decision affects private property everywhere.
Yes, I mean, the court could have restricted their reasons strictly to what is going on the Richmond land. And even that is worthy of discussion because there's some challenges on its face with the decision. But the court was very clear that no, this was intended to be a much broader application. And again, very clearly in black and white, the judge wrote what she wrote.
Were you shocked?
Yes, I think on its face. I mean, looking at the guidance from the Supreme Court of Canada on justifiable infringement, I believe, it might have been the last time I saw you, but paragraph 165 of Delgamuuk, one of the few paragraphs the court in Chilcotin lifted expressly, talks about the list of justifiable infringements to title being, quote, fairly broad. And then it lists a whole number of examples of what fairly broad looks like: forestry, mining, the settlement of foreign populations, which is, of course, homesteading, environmental protection, public interest concerns. And the reason, in my view, that the court said it was fairly broad is that if it wasn't, it wouldn't allow governments to govern, and especially in a province like British Columbia, where we have over 200 First Nations, all claiming or who have claimed title in some form or another. So if you had absolute title, you would have no room for anyone else to exercise any governmental authority.
And it seemed that the decision said that Aboriginal title is the senior interest, above government, above private property.
You are quoting verbatim, I believe. Yes, that's right, a senior interest in land. Again, with due respect to the court, that isn't how the Supreme Court of Canada described Aboriginal title, in my view. The Supreme Court of Canada, in numerous of its decisions, talked about Aboriginal title being a right to the land itself, not an interest in land. And for the non-lawyers listening, there's a big distinction, because once you start talking about an interest in land, all the normal rules around land apply. But that isn't the case with Aboriginal title. Many people will have heard the phrase sui generis, or unique. It's a unique element of land, a unique right to land. But it is a substantive right. But it's not like fee simple. They're similar in the sense that they're both exclusive rights to land. So there are similarities, but at their core, they are two fundamentally different sets of rights. One flows directly from the Crown, which is your fee simple rights to your viewers who own land. That is your title in sections 23 and 25 of the Land Title Act, which the court threw out. First Nations get Aboriginal title as a result of their prior occupation of Canada. And the balancing between the two, the only tool the government has is justifying infringements to title.
So you weren't the only one who was shocked. I think most people who read it at all carefully, does this really mean what it says? And one of the individuals was Premier Eby, because Premier Eby, with Haida and other issues around the province, has said, doesn't affect property rights, doesn't affect property rights. Everybody be calm. He immediately, I think it was within that day, joined the appeal of this decision, saying that's not what we'd intended.
Yeah, I mean, look, it was good. We did a little legal update on the decision when it came out, and it was nice to be able to quote Premier Eby for the first time in my career, talking about the interests of mortgagors and investors, again, whether they're Indigenous or non-Indigenous. We want to welcome capital to our great province, not scare it away. Having said that, between the Cowichan decision coming down and the need for the province to file its appeal, the Eby government slipped into court and filed its Haida Nation order, which on its face may look like they're similar. They're fundamentally opposed, because remember, the court in Cowichan said sections 23 and 25 don't apply to Aboriginal title. The Haida Agreement says provincial legislation will continue to apply on Aboriginal title lands. I'll leave it to your viewers to try to reconcile those 2 points. The second point is that while Premier Eby may be surprised by the decision, I think, again, many of us were, this has been a long time coming. I mean, for many of us in this area, we've been saying for, in my case, decades, that the province needs to offer more robust defenses and lay out a clear legal framework of how we can all live together in peace and harmony in British Columbia. They failed to do that. So I want to be clear, not the lawyers, the political direction to the lawyers. And so we end up where we end up.
And we will continue this conversation and find out where we go from here right after this message. The situation we've been describing sounds to me pretty bad, where we are with this court decision. Would you agree that bad is a proper description?
Yeah, I think so. I think that, it's unfortunate. I do think that the light is clearly on governments now to show some leadership, really for the first time in decades in our province. I'm proudly nonpartisan. So this has been building over decades and successive governments. We either come up with a long-term game plan for the province or we don't. And I think we've reached the point where we need that long-term game plan for both Indigenous and non-Indigenous peoples.
So there's an appeal going to the Supreme Court. What are the chances of that appeal overturning this decision?
The appeal will be going to the British Columbia Court of Appeal first, and then the parties could
We're all
seek
assuming.
leave. Yes, and I think that's probably a safe assumption given what's at stake and given the nature of the reasons in the lower court decision. Look, I think that the guidance from the Supreme Court of Canada to date is very, very clear, including the application of the fiduciary duty. For the lawyers watching and those who have read all 800 plus pages of the decision, you'll know that the court made some particular comments about the application of the fiduciary duty that led to sort of this absolutist view of what should happen.
Can you simplify that for me?
So I mentioned justifiable infringement, and this is one of the key tools government has to do the balancing of competing interests, Indigenous and non-Indigenous. It's government's job to do that balancing. The court has also said, look, when the Crown is making these decisions, it also has a fiduciary obligation, a duty to act in the best interests of First Nations if the Aboriginal title at issue is so significantly eroded that it would make having the title meaningless to begin with. And that was my point earlier, that if you did that on a parcel by parcel basis, how could you ever do a balancing? Because on a parcel by parcel basis, you couldn't justifiably infringe anything. So the only way to look at the court's comments on fiduciary duties is what the court did on treaty rights. You look at the treaty territory as a whole. And that's what needed to be looked at with Cowichan, was to look at their territory as a whole and look at the 1,800 acres, or what was ultimately determined to be title, 800 acres or so, and look at it through that lens. But if you look at it solely through the view that government must act in the best interests of, you never get to the balancing of interests. So this is key.
Here we are with this case and a decision that many people feel is really bad for the future of BC if it stands. How does government, since they're part of the appeal, how do they present their case to the next layer of court that's different? Because private property was brought up in the first case, but that didn't seem to affect the decision.
Well, if it was up to me, now whether the government does this, I think is really above my pay grade, as they say, because I don't know what this government will do. But what needs to happen is a vigorous defense of our land title system in British Columbia and an explanation to the Court of Appeal of the practical consequences to British Columbians if the decision is upheld. Second, focus on if in fact the declaration of title is upheld, whether it was justifiably infringed or not, make remedies available for First Nations like financial compensation from the Crown in the case that Aboriginal title is upheld. That will allow First Nations to purchase land on the open market on a willing buyer, willing seller basis, much like the treaty process did.
I'm wary of this willing buyer, willing seller, because if your land is now under Aboriginal title, who's going to be a really willing buyer, and won't the market value go down even if it's First Nations who wants to buy it?
Yeah, so I'm talking about a context where there was evidence of title, but not an actual declaration of title granted, a remedy available for the breach of that title, not both operating, as was suggested in the Cowichan decision, but absolutely an effect on market. Again, I'll let people who sort of play in that field speak, defer to them. But we've seen this, I have firsthand knowledge of what's happened on Haida, contrary to what the Premier has said. It's exact opposite of what I've observed. Again, I don't have any political axe to grind other than I think it's time to have a real honest discussion of what's happening. There was an interesting column in the Vancouver Sun last week about the secrecy. On the Haida agreement, there was all this talk of all the consultation that occurred. I have firsthand knowledge that yes, businesses and private landowners were consulted on Haida about whether they were in favor of a reconciliation agreement, which of course I would like to think 100% of British Columbians would say, of course, like me, we are in favor of reconciliation. What they weren't consulted on was whether or not their fee simple title would be part of an Aboriginal title agreement. They were not consulted on that. And so we really have to, if reconciliation is to be meaningful, this has to be transparent. And we have to move from the us-them discussion. And unfortunately, this is where the public governments are pushing us, is into an us-them. And that is not helpful. That is not helpful to the ultimate objective of reconciliation. And the blame is not on the courts, it's not on industry, it's not on business, and it's certainly not on First Nations and Métis people in British Columbia. This squarely lands with public government, and in particular our provincial government.
And how do we hold them account?
They seemingly ignored all the concerns out of the Haida Agreement. They ran into court to get their order after material concerns raised about the agreement and told that they would take it under consideration. Nothing was taken under consideration. They went in and got their order. So presumably it's by way of election.
So another complexity with this most recent decision is that two First Nations, at least two, disagreed with the winner. They really felt that they had land claims to title on the same areas. Was that just ignored?
Well, no, there was an analysis done, but you're quite right in raising this. I mean, so much attention, and look, I'm obviously going to be focused right now on the fee simple issue. We have First Nation clients that are also very concerned about the decision for that reason of how the evidence of occupation was treated by the lower court and what it means in 2025 after a First Nation has not possessed that land for more than 100 years. If you read, now I'm getting into some legal theory, but I'll just leave you with a sentence on this, that a big part of the court's description of being able to access Aboriginal title lands is current possession of the land. That is our interpretation of Delgamuukw and Chilcotin. Otherwise, your remedies may be limited to financial compensation. This raises, obviously, a much bigger question than we can talk about today. But I think for those First Nations, they quite rightly raise, serious concerns about the treatment of what it means in 2025 for a First Nation that has not possessed that land, assuming they did possess it at one point in time. So I'm assuming that there was actual possession. What that means when that evidence is over 100 years old. And I think that there's a very valid legal point to be argued there, because how do we settle all of this? If we're able to go back millennia on evidence, what does the future hold for British Columbia if we can't have some, I would say, initial starting rules to execute on reconciliation in a way that keeps our province together and keeps our province prosperous, so we can have bridges and roads and teachers and doctors and have people want to invest in our great province.
So the ramifications, if this doesn't get overturned for British Columbia, are what? Land title
Well, if it
overturned.
Yeah, that, if I may say, Carole, it's a provocative question. It's a straightforward question, but it would mean that British Columbia is really the only common law jurisdiction of which I'm aware globally that you would not be able to rely on your Land Title Act.
On that note, thank you so much for coming and talking this through with us, because it got attention the first day the decision came down, but I think everybody's forgotten about it. But it's an important issue. Back in a moment. So here we are, holding our breath, awaiting the result of the Cowichan appeal. Much depends on the outcome. Will BC's current land title system be upended and property rights threatened, as Thomas Isaac worries? Or will the court find a way to make reconciliation work? Let me know your thoughts on YouTube. Till next time, I'm Carole Taylor.